Well, good morning, good afternoon, good evening, and welcome to World Arbitration Update, the third edition. I'm very pleased to welcome you today. My name is Ian Laird. I am a partner at Crowell & Moring in Washington, D.C., and co-founder, along with my colleague, Dr. Jose Antonio Rivas, of World Arbitration Update. We created WOW 3 years ago because, well, we're in the middle of the pandemic, for one. It was a great opportunity to bring people together virtually. And we're continuing to follow that model. But it was also in recognition that international arbitration truly is a global phenomenon, and that arbitration and international practitioners and users occupy every corner of the planet, not just London and New York, where some of the big institutions are. And so we wanted to reflect that true diversity and the widespread interest and activity in the international arbitration space. And so this year we had the privilege of starting World Arbitration Update last week. We had some great panels in Mexico City, which was very successful. We were at the National Autonomous University of Mexico, and the first 2 days of WOW this year were under the auspices of the Mexico City Investment Arbitration Days conference. And we want to again thank the organizers of that conference. We had a really successful 2 days. We had over 950 participants in the various panels, and had some great discussions on the development of particularly of investor state arbitration in the Americas. And we've moved today to the Middle East, North Africa. We started the day with a great panel on arbitration in the Middle East. And today we're going to shift to a more African-wide topic. And our moderator for this panel, which is titled, let me make sure I get it right, The Protocol on Investment of the African Continental Free Trade Area, USMCA, and New Generation of Investment Treaties by Region. And this panel is moderated by my colleague, Dr. Jose Antonio Rivas. And Jose Antonio is the founding partner of X Strategy. That's a law firm here in Washington, D.C. And Bogota. He's also the chair of the Arbitration and International Law practice at X Strategy. He's a DC lawyer and a Colombian lawyer. He practices extensively in international investment and commercial disputes, both as a counsel and as arbitrator. And he provides advice in public international law and investment law to sovereign clients, states, companies, and investors. As you know, he is the co-founder of World Arbitration Update and Washington Arbitration Week, which will happen in late November, early December this year. Jose Antonio is a former counsel at ICSID. He's an adjunct professor at Georgetown University Law Center and has had wide experience in all the rules of arbitration and procedures and institutions. It's a real pleasure to work with Jose Antonio and the whole X Strategy team. We couldn't have put World Arbitration Update together without the huge assistance of folks like Maria Lucia and Juan Pablo and the whole team. And I just wanted to make sure we recognize the incredible efforts of putting this conference together. And last but not least, the support we've had from our sponsors and supporters shouldn't go unrecognized. We had an amazing group of people working hard to generate ideas and put our panels together. And we're very grateful for all those efforts. So having all said that, and welcoming everyone to this third edition of World Arbitration Update, I'm going to pass the microphone over to my colleague and co-founder, Dr. Jose Antonio Rivas. Good morning, Jose Antonio.
Good morning, Ian, and good morning, everyone. I know that as part of the tradition of World Arbitration Update, we are in various jurisdictions, and it is a pleasure to have today's WOW, or World Arbitration Update Africa. This is the day of Africa in our schedule, and as Ian indicated, we are addressing various topics in the African continent. And what a pleasure to be addressing today's panel on the Protocol on Investment of the African Continental Free Trade Area and new generation of investment treaties by region. There has been quite a bit of development on the protocol specifically, that development has been in parallel to many other developments of investment reform or creation of new models. And I just want to take a second to emphasize that this treaty, as our speakers will share with the whole audience and the world itself, is one of, at least in my view, one of the most avant-garde investment treaties that now exists in planet Earth, to put it this way and mildly. It does many things which our speakers will share with everyone, including really providing provisions, or including provisions that are not seen in any other treaty, and they go well beyond procedural modifications. They go into the substance and include various obligations, not only for the states, which is very traditional, but for investors. I won't steal anybody's thunder, but before going into the substance, let me introduce you our really incredible panel. And I know that this might take a few seconds, but I think that it's for the record and for everyone to know who we are with. I will start with Michael Imran Kanu, SJD, or doctorate. He is ambassador and deputy permanent representative of Sierra Leone to the United Nations. He coordinates and leads several processes at the UN, including the African Group of Experts on ISDS reform in New York. He, of course, holds an SJD in international business law from the Central European University, and he's a UN International Law Fellow. And we could go on and on because he's way more, but we'll stop there. And next, we have Sadia Bhatti, who is a partner with GIDE's Dispute Resolution Practice Group in London. She has more than 13 years of experience, including in Paris and New York, as counsel to private and state entities in cross-border disputes, in particular in international arbitration proceedings, both on investor, state, and commercial, governed by the rules of various institutions, especially in the energy, oil, and gas and construction sectors, particularly in Africa. Sadia also advises governments in the drafting and reform of their investment treaties and national legislation, which she did most recently for the Ivory Coast. She is also part of the task force of the AFCA, the treaty that we're addressing today, Secretariat, on the investment protocol, and she lectures in universities around the globe, most recently in Sciences Po in Paris and Cambridge University Business School. Next is my esteemed friend Makani Moise Mgenge, and who is also the brain behind this panel. In reality, I mean, this panel was really truly conceived by Makani, so I'm very grateful for his input and for bringing the experts to the table. Makani is a professor of international law at the Faculty of Law of the University of Geneva and director of the Department of International Law and International Organizations. He's also an affiliate professor of Sciences Po in Paris. And since 2017, he has presided the African Society of International Law. He is a member of the Hague Academy of International Law and an associate member of the Institut du Droit International. He has acted and acts as expert, advisor, arbitrator, and counsel on international law for states and international organizations, including with respect to disputes before the international courts and tribunals. He is involved in negotiations of several investment agreements in Africa and is the lead expert of the task force of the Protocol and African Treaty Secretariat on the investment protocol for the AFCA. Next is Suzy Nikiema, who is a director of sustainable investment at the International Institute for Sustainable Development. So you can see the logo of her institution up there. She provides legal and policy advice on sustainable investment governance, assisting developing countries in investment legal instruments design, negotiation, and implementation. She is also a member of the task force of the African Protocol on Investment. And in addition, she teaches investment and mining law in universities at Burkina Faso. And last but not least is our presenter, who is Hamed El Kadi. You can see Hamed right there with the UN logos and also a beautiful cat in the background. He is leading UNCTAD's works streams in international investment agreements and investor-state dispute. He has over 20 years of international experience in the areas of investment and development, including policy research, international consensus, building, and technical assistance to governments in institutions in over 160 countries. He led the formulation of global guiding principles for a new generation of investment policies and played an instrumental role in the adoption of the AFCFTA investment protocol. He's a core member of the UNCTAD team on the World Investment Report and the World Investment Forum. So with that, I would like to emphasize how important is some of the knowledge and work of some of our experts. And Hamed, I would like to basically welcome you and ask you about the new developments, especially in the African region, of investment treaties and what you have seen. The question is from, for Africa, but also from Africa to the world, really.
Well, sorry, thank you very much, Jose. It's a great pleasure and honor to be with you today with such a distinguished panelist. Greetings to all the participants that are with us today. So perhaps allow me to make a brief presentation to set the stage for the ensuing discussion. I think that is extremely important on the latest trends in investment policy making, with a special emphasis on Africa. Maybe 2 minutes on a background. The bulk of the investment treaty regime was concluded, as you all know, in the 70s, 80s, and 90s. It comprises around 3,300 bilateral, but also regional and plurilateral treaties with investment provisions. Now, the number of the old generation treaties, the ones signed decades ago, significantly outnumber generation agreements. And they are characterized by their very broad scope, so covering investments across all sectors and including very vague substantive protections. Since that time, the world has been hit, unfortunately, by what we can call a successive global crisis. We had the financial crisis, followed later on by the pandemic. We have the war in Ukraine and the impact on food security, the debt crisis, the rising inequality, and of course, climate change. So the legal framework for investment really needs to be adapted to the challenges that we are collectively facing today, collectively. The question is how to move from a system that used to put at its core investment protection to a system that maintains investment protection, but not at the expense of countries' interests and right to regulate. The overwhelming majority of investor-to-state cases that are based on treaties are pursuant to treaties signed in the 70s, 80s, and 90s. Some of the measures that governments took to tackle the crisis that I've mentioned and to protect public policy objectives have been challenged by international tribunal. So we all recognize the crucial importance of foreign direct investment as an engine for economic growth, innovation, development. Many of the actual real solutions to global crisis are not possible without, a solid legal framework for foreign investors. But this should not come at the expense of countries' ability to implement measures for the protection of their people. We have seen measures for the protection of the environment, financial regulation, energy, public health, all being challenged in international arbitration on the basis of treaties signed decades ago. Allow me to now go more specifically into specific trends in 5 minutes, if I can. First, we are witnessing a rise in the number of treaty terminations, which in the past 3 years, investment treaty terminations have exceeded the number of newly concluded investment treaties. At the same time, the old generation investment agreements maintain their dominance in the IIA universe. Over 88% of IIA relationships are based on treaties signed before 2010. And 40% of the relationship created by a new generation investment treaty coexist with an earlier treaty between the same economies. A third trend is really, and I think here touching a little bit on the substantive issues, that new generation agreements, the ones concluded recently, include a large number of innovative, reform-oriented provisions. We are seeing this across all continents. They aim to safeguard primarily the host states' right to regulate, reforming investor-to-state disputes, and very important, providing precise and clarified definitions, refined standards of fair and equitable treatment, national treatment, MFN, clarifies what do we mean by indirect expropriation, general exceptions for the protection of environment, labor, and health. They also, the new generation treaties, increasingly, and this is a very clear trend, include provisions aimed at investment facilitation and investment promotion, while ensuring the responsibility of investors as well. So is this good enough? This is a big question. Of course, it is a very positive step forward, but it remains to be seen whether these reformed agreements are sufficiently robust to effectively support countries' implementation of their legitimate policy measures. I'm saying that because we have seen in some cases that even reformed-oriented provisions can be interpreted by arbitrary tribunals in the most unexpected ways. The fourth trend is really and really connected to the African Investment Protocol is that we are seeing a very big rise of mega regional investment treaties, as opposed to your traditional bilateral investment treaty that has 10 pages, very broadly drafted. Now you have elaborate regional investment agreements that cover trade, services, and investment, among other things as well. We are seeing the African investment, the investment protocol of the ACFTA. Other examples include the RCEP, the USMCA, the CPTPP. And really, if you look at them, they all converge in terms of substantive provisions towards ensuring, again, a balance. That's what they are trying to achieve in the investment provision, but to different degrees, of course. So there may be less bilateral investment treaties in terms of quantities, but one regional agreement, because of the multiple parties, create multiple relationships. So one treaty, in fact, is equal in terms of relationship to a large number of bilateral investment treaties. So Jose, allow me to conclude here by maybe providing some recommendations or ideas of what is needed. I think clearly what is needed is more coordination, more synchronization, and to look at the investment treaty reform issue from a holistic view, instead of a piecemeal approach, reforming some provisions, reforming this bilateral treaty, amending this, looking at the procedural aspects only, looking at the substantive provisions of some treaties only, without looking at it in a more consolidated and coherent manner to see what can be done for an effective and long-lasting solution. You have some countries that are focusing primarily on forward-looking reforms, so concluding new treaties that are more balanced, but then maintaining the existence of the old, very vague investment agreements. So you maintain the old treaties, but sign new ones. You have other countries who are fully committed and putting all the efforts into the reform of the ISDS system without necessarily engaging in the reform of their existing old treaties. You have countries developing model bits. You have countries favoring the soft law approach by adopting guiding principles on investment policy making. So this is really what we need the most. And UNCTAD has been working on this for many years now across our three pillars of work, which is technical assistance, conducting reviews of countries' IIA treaties, development of model bits, conducting research and policy analysis, and consensus building. Finally, we have also developed, it will become publicly available in 2 or 3 weeks' time, a new toolbox for IIA reform, but with a special emphasis to help countries develop investment treaties that are conducive to the energy transition. And then we will have in October our big World Investment Forum, covering over 140 conferences during 4 days. And within the World Investment Forum, we will have no less than 6 high-level meetings on investment treaties. And we really anticipate concrete and positive outcomes that I hope will enhance the global coordination efforts on IIA reform. Jose, I stop here and I thank you very much, and I remain with you for the rest of what I believe will be a very interesting conversation.
Thank you very much, Hamid, and I mean, thank you for for being the presenter for this session, and also for giving us a baseline of what has been going on in Africa and in the world in terms of investment treaties. One question that I have for you is, when is this toolbox going to be released? I find that very interesting and useful. So perhaps you want to say about when in 2023, hopefully, will that toolbox be released?
Thank you, Jose. The toolbox is part of the World Investment Report that we are finalizing now. So it will be released, I think, in 2 or 3 weeks' time. It will be publicly available as part of Chapter 2 of the World Investment Report.
Wonderful, wonderful. So when it's released, we hope to put a link to in our website so that people can have a look at it. And now. I would like to turn to Professor Makane and have his take on how these new trends of investment treaties may have informed the negotiation process of the investment protocol of the African Continent's Free Trade Agreement. Professor?
Thank you so much, Jose, and good morning, good afternoon to everyone. It's great to see many familiar names of colleagues and friends in this webinar. And thank you, of course, to Ahmed for setting the scene and guiding us through what are today the new trends. And Jose, I think that Ahmed has emphasized 3 very important trends today in international investment lawmaking. Which is first balancing rights and obligations of states and investors. Second, preserving or guaranteeing the right to regulate of states when it comes to investments on their territories. And third important trend that has been emphasized by Hamed is of course the need to promote, facilitate, and protect sustainable investment. So these are the 3 new trends we can see, even if it's at different levels in new generation of investment treaties. And something I wanted to say just to start, Jose, is that in Africa, we've been trying since many years to incorporate those new trends in African investment agreements. I always like to say that maybe Africa has even been quite pioneer in trying to incorporate those new trends. For me, one critical year is 2012. In 2012, there were 2 major episodes, 2 major events in Africa in relation to modernizing investment law on the continent. The first one was the adoption by SADC. The SADC is the Southern African Development Community. It's one of the regional economic communities in Africa, which adopted a model BIT template, which was very much sustainable development oriented. In that model BIT template, for instance, Jose, investor obligations were incorporated. Investors' obligation in relation to the environment, in relation to human rights, in relation to corruption, etc. So it was a quite, I would say, rather pioneer moment to do so in 2012. And then in 2012, the second major event in Africa was the launch by the African Union of the very famous Pan-African Investment Code. And the whole reason behind the Pan-African Investment Code was to basically codify. They used the word codify. I don't know if at that time it was right to speak in terms of codification, but the African Union say, let's codify the best practices, let's codify the new trends in investment law making to guarantee sustainable investment in the continent. So this is how things started, I would say, in the continent. So it is not surprising today. It is not surprising today that the investment protocol to the AFCFTA, that the investment protocol to the African Continental Free Trade Area is mostly focusing on regulating or incorporating new trends to promote, facilitate, and protect sustainable investment on the continent. I believe that the investment protocol at this level is just a continuum of trends that have been set forth in the continent for the last 10 years. So the investment protocol, maybe for the friends and colleagues here who are not very familiar with that, maybe many colleagues here know that since 2019 in Africa, we have created a new free trade area that we call the African Continental Free Trade Area, and the acronym is AFCFTA. And the AFCFTA has been launched since 2019, but the AFCFTA is supposed to be based on several phases. The first phase of the building of the AFCFTA was dealing with trade in goods, trade in services. And last year, negotiations were launched for the second phase of the construction of the building of the AFCFTA. And one major pillar of the second phase was, of course, the negotiations of an investment protocol. So whenever you hear about this investment protocol, it is a protocol to the African Continental Free Trade Area. It is supposed to regulate intra-African investment in the continent. And so in terms of the new trends that Ahmed was speaking about, it's very interesting when you look at the negotiations of the investment protocol to the FCFTA. It's very interesting to see that from day one, governments were actually keen or concerned that the investment protocol would reflect the best new trends, best new practices that have been developed and in Africa and across the world. And something we did that is very interesting with the negotiations is that a document called Principles for the Negotiations of the Investment Protocol was adopted to bring as much as predictability, to make sure that governments would not, question the fact that this protocol has to reflect the best practices. And in terms of techniques, and I will finish on that, Jose, in terms of techniques that have been used to guarantee that best trends, best new trends, best practices would be contained in the investment protocol, I think it's rather interesting to look at that document. 5 techniques were actually set forth in that document. First technique, what I would call the technique of renvoi. The principles for the negotiations of the investment protocol make a renvoi, for instance, to UNCTAD, to the principles, guidelines that have been developed by UNCTAD, to make sure, because we know that UNCTAD work is ongoing, is dynamic, so to make sure that at the phase of implementation, whatever is being developed by UNCTAD, like for instance, the toolbox that Ahmed was referring to, would be taken into account. So we use that technique of renvoi. We use the second technique, which is what I would call a technique of systemic integration. For the negotiations of the investment protocol, it was made clear that best practices in Africa, but also outside Africa, so meaning in Latin America, North America, Europe, Asia, would have to be integrated. So whenever a provision was proposed during the negotiations, what would happen is that you would have to say where the provision is coming from. Where is this best practice coming from? USMCA, CAI, China, EU, is it coming from Mercosur? You would have to say that to actually avoid even that some countries would try to tell you, no, let's go out of all that. So you would have to prove that, the provision you are trying to contest is not actually based on a best practice. Third technique that we used in the negotiation was the technique of policy coherence. When it comes to new trends in investment lawmaking, those new trends are not just limited to investment treaties. You have today new trends, best practices that are stemming from other international treaties, climate change treaties, human rights treaties, environmental treaties. So we made sure also that all these new trends that pertain to investment law would also be reflected. in the investment protocol, and that's what I call the technique of policy coherence. And then first technique that we use was what I would call a technique of institutional difference. And Michael and Sadia will talk about it later, but we made sure that the investment protocol would also reflect new debates, new discussions at UNCITRAL. When we were negotiating it last year, as you know, there was ICSID revising its rules. So we made sure that there would be this institutional difference to those ongoing processes. And then last but not least, and I will finish on that, which I think is very interesting, is that we said, okay, great. Let's incorporate best practices, new trends, and so on. But fifth technique, a technique of Africanization. Let's make sure that all these new trends or best practices that we would incorporate would be adapted to African needs, would reflect African developmental needs. So we didn't just do some cut and paste. We made sure that everything would be put there would be Africanized. So these are the techniques we use in relation to the new trends that Ahmed was referring to make sure that the protocol would be comprehensive in terms of reflecting those new trends. Thank you, Jose.
Thank you very much, Makani. And I find amazing the amount of work that African states and representatives have been doing. And as you say, it has not been for the last 4 or 5 years. It has been done for since at least 2012, but I am sure that even before that. I want to emphasize one aspect that you indicated, which is the binding character of some provisions and obligations for investors. I, as a former negotiator of various investment treaties, in the case of the Republic of Colombia, I know very well how difficult it is to have obligations for investors that would not be soft law. Many of the treaties that are out there, I wouldn't say many, but some of the treaties that are out there that are in force have some obligations for investors, but they're really soft law. So hortatory language that advise states to advise themselves, the investors, to try to comply with ESG standards or social corporate responsibility standards, and those are very that's very quote unquote nice, but it's not obligatory, it's not mandatory. Here the difference is that the SADC, as you said, and now the protocol have binding language, hard law, that creates obligations for investors with respect to human rights, with respect to ESG standards, with respect to corporate social responsibility, and that's a huge difference. I could not emphasize how big it is. So that is a point that I wanted to emphasize, and I now would welcome Michael's, Monsieur l'Ambassadeur, remarks on the process of negotiations of the investment protocol. What do you find most important or most striking? The guiding principles, the content. You have 2 minutes for that. Not an easy task.
Thank you, Jose. Indeed, it's not an easy task. First, let me thank X-Strategy for the kind invitation. I think it's wonderful to be in the panel with the distinguished colleagues. I want to thank you for setting the scene, and of course Ahmed for the update, and certainly Professor Makan for really dilating on the important aspects of the investment protocol of the AFCFTA. Now, as an outsider, meaning that I wasn't part of the negotiation, it's really important and helpful to hear from Professor Makan the very good practices that were adopted in the negotiation, including the principles and the important trend. But I also appreciate the fact that he also dwelled a bit on the techniques. So I'll just briefly share 3 quick points from this outsider perspective essentially to comment on the work that's been done. So firstly, I think we all should really congratulate the negotiators for concluding such an ambitious instrument. I think for your comment already, Jose, it's sort of agreeing with the view that one, it has the mandatory provisions, but also it has been an ambitious time frame from last year. We have such an ambitious instrument. Of course, there could be some challenges and drawbacks when it comes to such speed, particularly in the process of negotiation, and this may relate to questions on inclusivity and transparency, but I'll get to this part by the end of my 2 minutes. The second point really relates to the opportunity that was afforded to the negotiators, in essence, to the African state, to address really the big substantive concerns relating to investment, sustainable development, and investment protection. So again, the third point of the important trend with Professor McCann mentioned, so I don't want to repeat that. Now, why is that important? It is important because you can contrast that to the challenges we are facing as negotiators from the African member state or observer states in the multilateral context. So whether it's the UNCITRAL Working Group 3 or in looking at the work that was done by ICSID, but also the failure by the International Law Commission, for example, to move the topic fair and equitable treatment standards in international investment law to its current agenda. So you see this, it's either a phobia or the reluctance to address substantive issues in the multilateral context. And so this provided the opportunity for the African negotiators in the FCTA to address those big issues. The third point is really rather a question for assessment. That is whether the investment protocol has been aligned, and I think I had a bit of this, to the other processes in which the AFCTA members are engaged, particularly, for example, the UNCITRAL process. So would the AFCTA ideas influence the ongoing negotiations, for example? I think that is something which we have to contend with in the negotiation. So instead of concluding this brief reaction, one has to note that the process may have been different, clearly state-led, and it's different from the mandate that was given to Working Group 3. And perhaps in terms of looking at, for example, the annex, the suggestion may be that a bit of diversity in the voices could enrich the process, but the AFCTA members could still maintain the control of the product. But however, that said, it is very difficult to argue with the final product of the AFCTA negotiation, the investment protocol, when you look at how ambitious the provisions have been. On the whole, I will say remarkable work done with lessons to learn to improve the process. And we look forward to using the ideas in the protocol, in negotiations in UNCITRAL Working Group 3, for example. So I believe that's 2 minutes, Jose. Thank you.
Yeah, well, thank you very much. That is a very substantive reaction. And now I would like to turn our attention to Susie Nikiema. Susie, it is a pleasure to have you. And the question for you, I mean, and of course you have your full 7 minutes. The question for you is one of the relationship between the protocol and also the notion of sustainable investment and development. How do you think that, I mean, was that achieved? Do you think that the provisions that we have in the African Continent Free Trade Agreement protocol are provisions that will foster the development, but in an environmentally sage manner?
Thank you very much, Jose, and good morning or good afternoon, everyone. Thank you first for inviting me to speak to this important topic with such estimated experts and colleagues. And thanks to Hamed and Ambassador Michael and Professor Makan, well set the scene before my intervention. Yes, to respond to your question, I think the protocol on investment under the AFCFTA is definitely a significant document. And I think I'm just repeating what was already said by some of the presenter. And I believe it has a real potential to boost sustainable investment and development on the continent. And this affirmation is based on the numerous innovations in the protocol. And these innovations, as Professor McCann said, consolidate good practices, both in the continent, but also taking into account best practices at international level. Of course, saying that this instrument is innovative is one thing. Of course, its real impact will depend of first its entry into force, and then how it will be implemented, right? So what are these major innovations that, if applied correctly, could make a difference in the governance of sustainable investment in Africa? Of course, there are many, but I will mention just a few of them, the most significant ones, because we don't have enough time to go into the details. And it starts first, of course, with the preamble. Professor Makan already touched a bit about that, but since we have our colleague Hamed El-Kadi from UNCTAD, I cannot refrain to mention, for example, that the preamble of the protocol refer to the UNCTAD investment policy instruments that support new generation investment policies for inclusive growth and sustainable development. And this is something that Hamed highlighted in his introduction. But more generally, when you take the preamble of the protocol, you will see that it again and again refer to role of investment is expected to play on sustainable development. So it's not just about investment, but investment that brings sustainable investment in state parties. Now, when you go in the substance of the text, and I will just highlight a few elements here again. First, we can say the protocol puts sustainable investment front and center. Indeed, when you take the definition of investment under the protocol, they are defined as assets that make a real contribution to development, not just serve only an economic function. That's something important. And the protocol is clear, for example, that it only applies to investments that are already established in state parties and in compliance with national laws and regulation of the host states. Something that Hamed, I think, presented as a best practice we are seeing now in terms of new generation of investment treaties. So that's one thing. Another important thing is that the protocol comprises a standalone sustainable development chapter. I don't think we are seeing this a lot in investment treaty making. So it's not about just putting few provision somewhere in the treaty, as Hamed were referring to, but having a full chapter on that. And this chapter include provision, for example, like state right to regulate, which is reaffirmed in the protocol, right to regulate in the public interest, but also provision regarding minimum standard on environmental, consumer and labor protection, climate change, reaffirming the commitment of state parties under the Paris Agreement, transfer of technology, all of these elements that are really conducive for sustainable development and on which the state party made some commitment to improve and enhance the legal and policy framework in that regard. Another key element, and I think that's also something that has been mentioned by yourself, Jose, I think, is that the protocol takes a balanced approach to investor right and obligation. I think also Professor Makan talked about this, one of his principles, right? Balanced approach. And this is something important because the investor get robust framework under the protocol, under Chapter 3, but they also have clear responsibilities to host states under Chapter 5. And again, here, it's not about adding one or two provisions, but the protocol goes into specifics about investor obligation. You said it's so hard to negotiate this kind of provision. In the protocol, they are specific and they are using binding language. So we are using the shall here. And you will see obligation regarding protecting human rights, labor rights, environmental safeguard, anti-corruption, anti-bribery, taxations, etc. Another, and I will go a bit quickly on that. Another very important element of the protocol is that it's also it's not only about protection, but it also cover promotion and facilitation of investment. Because usually investment treaty, we are only about protection, but here it is making also providing provision on investment promotion and facilitation, but again, linked it to sustainable development. And for example, in chapter 2, you will see a provision encouraging state parties to collaborate and coordinate when it comes to investment facilitation and promotion. Something I would like also to highlight, and I think it's really important, is taking into account the main objective of this negotiation being to streamline investment standard on the continent. The protocol is coming with a very innovative approach, which is to outline the path forward to deal with existing intra-African bilateral investment treaties and regional economic communities instrument on investment. And I think Hamed El-Kali highlighted the fact that we have too many old generation of bilateral investment treaties still in place. So the protocol provide a call specifically for termination of existing intra-African BITs within 5 years of its entry into force, and also alignment of regional economic communities instrument within 5 to 10 years. So the idea is really to come up with a streamlined investment standard on the continent. Last but not least, and I will finish here, and I hope I'm still within my time frame, the protocol is also laying the foundation for the establishment of a Pan-African trade and investment agency, which is very important because if you want to make sure that what is provided in the protocol is implemented, having an institutional framework is so important. So this agency is supposed to support the implementation of the protocol. Also, something that is envisioned, and we are not yet in terms of negotiation, but I want to enter into the detail, is that the protocol provided that an annex on the procedure for dispute prevention, management, or resolution will be negotiated. So that will be another step. So, and to stop here, I think there are many other innovative features in the protocol that can help foster sustainable development in the continent. But I will stop here, maybe with a final remark on the fact that the protocol is a potent tool for modernization and harmonizing investment rules across Africa. But of course, it's now time to effectively implement the commitment in the protocol if we want it to operationalize its benefits to the government, to the investor, to the people in Africa. Thank you very much.
Thank you very much, Susie. And I know of the protocol and I have read it, but in your words, because you have been in the trenches, it's amazing what has been achieved in terms of technical standards, but also a way to harmonize in either 5 or 10 years the whole history of investment treaties with a new African more continental perspective, and hence the name. This is something that in all truthness was attempted to be done in the Americas with the free trade of the Americas, and was not done. Some trade agreements came out of that. This is something that was tried in 95 with the multilateral investment agreement or treaty, which was not done. And I think that the African continent is giving a huge example to the whole world by including substantive provisions and a transition without kicking the launch, as we say in some places. The African continent is not doing away with investment arbitration. It's balancing it. It's making it better, but it's still in accordance with the international rule of law. And that's my editorial comment, not like other continents might be doing in any event. Sadia, I would like to invite you for a 2-minute comment on your views on the sustainable development included in the agreement.
Yes, thank you very much. Sorry, I just wanted to share my screen, and I hope you can all see it, but please shout if you don't. I just wanted to give some brief comments on what Susie has mentioned and other speakers as well. First of all, thank you very much to everyone for the invitation and for the organization of this wonderful event. One thing that came clear for Susie's comments and Professor Bang's and previous speakers as well is that this is an innovation in terms of environmental standards. And here I'm talking about environmental standards only. That is not new. So the protocol and investment arbitration, as Professor Bang and Susie have mentioned, have been the work of a lot of states for a very long time. And if I may, just in my 2-minute comment, say that there's been a change going on the continent for a long time. First of all, at the national level. So you can see here, this is an example of what has changes in the Ivory Coast alone, just to give you an illustration of a state where you have a reform of the investment code that incorporates, because you were talking about soft law obligation, not just soft law obligation, but hard law obligation with respect to environmental standards. And as we all know, why is national law important? Well, A, because treaties refer back to national laws, right? But also because, and this is a specificity of the African continent, you have 43% of investment treaty disputes have been on the basis of contracts on the African continent. I repeat, this is 3% versus only about 15% generally speaking, because on the African continent, you have a lot of investment codes that give a direct consent to arbitration, but we'll speak about that a bit later. So this was why it was important for the national legislation to also change with respect to environmental standard. And this has been going on for a while. This is a recent example. The second thing I wanted to mention about, Susie giving a very comprehensive overview of the protocol of investment arbitration, these are provisions that are innovative because the African states have been incorporating environmental standards in their treaties for a long time and recently as well. This is, UNCTAD, OECD actually, that mapped out just to show that the recent investment treaties all include, and you will see here, the percentage of new treaties with references to environmental concerns, which are environmental obligations. Some of them are soft law, but a lot of them are hard law. And if I may just use a few minutes just to, without going in too much detail, but give you specific examples of clauses here that UNCTAD have referenced with respect to environmental standards. You have a list here of what kind of clauses you have, but I'll go very quickly. What's important is giving you a specific example on the continent. Of course, we've got, the Morocco-Nigeria BIT that is often referred to, but I think it's important to mention it again with respect to obligation to pre-establishment of investors with respect to environmental standards, obligation post-establishment with respect to environmental and human rights standards, and corporate social responsibility. You have a few other, examples of recent BITs, 2019, 2018, signed by African states and other states, which incorporate those environmental standards. And you have specific prohibitions and restriction clauses, which I think are very important, which means, that you can't, here, this is an example of the China and Mauritius BIT from the 90s. The provision of this agreement should not in any way limit the right of either contracting party to apply prohibition or restrictions, which is directed for security interests, protection of public health, diseases and pests in animals or plants, or the protection of its environment. This is very important. So this has been going on for a while, and you have examples here of intra-African BIT that have incorporated those provisions from the early 2000s. Okay, and I know we heard from Susie that these are all going to be terminated with the AFCFTA protocol, but this is to show the trend of these countries incorporating those provisions, and of course the right to regulate, which Professor Bang insisted was very important, that has been also incorporated in BITs from African countries for a while, and you keep seeing this provision over and over again in investment in investment treaties today. You also have specific provision that prohibit the reduction of the environmental standards. And here you have additional examples here from the early 2000s and the late 2000s. So, you know, I have other examples, but I know that my time is going up. Maybe I'll also just finish on saying that, you know, there's been work also on model BITs that have been done, of course, as you know, and the most recent example is a AAA model BIT for African states, which Professor Beng, of course, contributed to as well, which have the specific provisions on environmental standards. And the ASC-ADC model was, of course, mentioned already before, but here they are for reference purposes. So I'm gonna skip through those. But you have additional examples here of environmental impact studies that are in African BITs specifically. But I may stop here because I know that my time is limited, and I don't want to go and abuse my time too much. Thank you very much.
Thank you very much, Sadia. I think that the beauty of World Arbitration Update is that our sessions are recorded, and to the extent that you have been incredibly diligent and putting up these beautiful slides, we will have for our use and everyone's use. So thank you very much. Now,
Jose,
yes,
I just want to say, because Sadia mentioned what she called the AAA model BIT, and I think for our audience, it's good for the audience to know that it's the Africa Arbitration Academy model BIT. That it's the Africa Arbitration Academy, which was being led by our brother, Professor Mohamed Abdel Wahab from Egypt. And they drafted this great model BIT, which is, again, I think, another illustration of how Africa is now being rule makers when it comes to investment lawmaking. I just wanted to make that precision because it's a great example that Sadia has referred to. Thank you.
Thank you, Makan. No, that is very useful to know what AAA means, which is not an insurance for cars in the US, but rather the model BIT of the African Academy. Well, let me move on to Ambassador Michael and ask him specifically what are his views within the Ancestral Group 3 process, and what are his views as enriched and nurtured by the African perspective. And this question, I apologize for the question in a way, because I know that to try to generalize in one perspective all of a huge continent is an oversimplification. So within that question, I understand that there may be more than one view, but let's start there.
Thank you, Jose. Indeed, I agree with you that we may not want to oversimplify, but then as you kindly introduced me, I do have the honor of coordinating the African group at the expert level in New York on investor-state dispute settlement. And so I would share perspective based on the comments and submissions that have been made by African members and observer states. Because of that role, I've had the opportunity to interact with officials from the AFCTA context, but also representatives of the African member states and observer states of the Commission. So what this has led to is really the understanding and the realization between the two actors that both processes are important to change the existing ISDS system. So in this sense, I think the focus will be on the investment state dispute settlement and reform process, given the mandate of Working Group 3, and how really there is need to address the challenges which have been identified in relation to investor state dispute settlement. And so when we look at the investment protocol of the AFCTA and also the procedural matters that have been addressed in Working Group 3, the important point and the issues which may come to mind, for example, is reverting to what the drafters of the AFCTA express, meaning that they were mindful of the practices including incorporating best practices from the Pan-African Investment Code we've had from Professor Makan, investment instrument from the regional economic communities, including the SADC instrument that they referred to, national laws, as well as other relevant international investment instrument. So that's a good perspective to take about building on existing instrument, the Renvoi, as he said. And then we note that part of the objective of the protocol is to establish a balance, so a balanced, predictable, and transparent continental legal and institutional framework for investment. And this will take into account the interests of state parties, investors, and local communities. So in noting that objective and the scope in the instrument, it's clear that there's a difference in approach and objective to what seemed to be the interpretation of the mandate of Working Group 3. I'll get to the restrictive interpretation of the mandate of Working Group 3 shortly, but I just wanted to highlight that one distinction. In this 7 minutes that I have, I really do not intend to get into the substance of the AfCFTA investment protocol standards, but really one cannot fail to see that, for example, there is no fair and equitable treatment. It is not part of the investment protocol standards. I think that's a big exclusion. One can also not fail to notice that there's one chapter, I think Susie has really described and talked about the chapter on sustainable development related issues excellently. And as you said, this is really at the heart of investment and sustainable development. Also, I think it has been said that there is provision on investor obligations, so one cannot fail to see that in the protocol. And finally, just taking this quick survey in the AfCFTA investment protocol, the big issue really in terms of dispute settlement is the management and settlement of dispute. And we can see a reversion or the preference for state-to-state dispute settlement as a mechanism adopted in the protocol. The protocol also seemed to have adopted a tiered approach, wherein, of course, you start with the usual trying to resolve issues amicably or through consultations, negotiations, conciliation, and mediation. There is, of course, the other part of other mechanisms available in the host state. And perhaps a question for consideration, particularly for the negotiators, is this inclusive of ISDS? Because we don't see ISDS in the protocol, but of course, there is this other means of other mechanisms available in the host state. So once we got towards this point, and that answer you may find when the annex will be negotiated, it's good to contrast this with what has been going on in the UNCITRAL context. Now, when you look at the UNCITRAL mandate, again, the Commission entrusted Working Group 3 with a broad mandate really on possible reform of ISDS. So in the first place, it should identify and consider concerns regarding ISDS. Secondly, it should consider whether reform is desirable in light of the identifiable concerns. And third, if the working group were to conclude that reforms was desirable, then it should develop any relevant solutions to be recommended to the Commission. I think the working group is now working on the third leg, given that it has agreed that there are concerns. The Commission also agreed that there should be broad discretion left to the working group in discharging its mandate. However, and intriguingly, a number of states have interpreted the mandate of the working group to address procedural issues only. And so I find this interpretation to be artificial, and it's an artificial limitation. But owing to the consensus rule in the working group 3, as much as you hold a different view, there's nothing you can do if other states believe that that's the limitation. What that has led to is the fact that there's a frustration, particularly by African states and African observers, that we cannot address the substantive issues which are of concern to most African states. Indeed, the working group has identified that there are concerns regarding ISDS, and that consideration should be given to identifying desirable reform options, including addressing the issue of the systemic lack of consistency and correction of decisions, cost, duration, the lack of appropriate diversity among persons appointed to serve in ISDL tribunal panels. So, significantly, the working group has concluded that this reform is desirable and has opted for 2 streams. So we have the option of structural reforms, including the establishment of a multilateral investment court, that's a standing mechanism, or to, a preference for, bilateral options, incremental reforms. This is referred to addressing some of the low-hanging fruit. In view of the aspect of work that has been referred to as procedural reform options, which may be applicable to both streams, that is early dismissal, security for cost, allocation of costs, counterclaim, and third-party funding. I think there will be agreement that these are quite limited in addressing some of the critical concerns of the African states or African observers. When we address the issue of the cost-cutting issues in the ISDS reform option, the African member states were able to discuss and look at possible issues which may be included, and invited really the Secretariat to add or take stock of these issues which are not in the main frame of discussion currently in ISDS. And when you compare those issues to what you find in the protocol of the AFCTA, you will see an alignment. So for example, the Secretariat was invited to prepare draft provisions on issues relating to damages and compensation, considering recent practice. The African members and observers were able to wear firm and call for the protection of the state's rights to regulate, to ensure that development goals and principles are protected and safeguarded, that's sustainable development. There were calls for carve-outs and exceptions to limit the scope of dispute settlement provisions to investors that do not follow requirements of nationality, or those that do not have substantial business activities in the territory of the host state, or those that do not comply with local laws and regulation of the host state. There was also an invitation for provisions to allow for recourse to domestic courts and jurisdiction, deferment to judgment of the highest domestic court and jurisdiction of host state, calls for strengthening and broadening the role of state-to-state mechanism for the settlement of international investment dispute. And of course, in opening dispute settlement proceedings to third parties, this should include local communities that are hosting the investment. And the invitation was for the Secretariat to really take a survey of what's happening and map out recent treaties. And I think in this area, the FCTA protocol will play a significant role in shaping the conversation. And so as we are in Working Group 3, we don't have coordinated position, but I think what the investment protocol would do is to make it easier for common African position to be developed, particularly on this other procedural reform options, even though there's this view in the working group that we cannot get into the substantive issues. We think there's a good inroad to doing this, and this is because of the very progressive, pioneering, or avant-garde, as you describe it, investment protocol of the AFCTA. I think I'll stop at that and leave it to the others to come in.
Thank you so much, Michael. I would like to. I struggled to formulate the following question, and I decided to formulate it as a matter of fact rather than as a matter of opinion. The question, and I believe that I know the answer, but you are the expert. The question is whether the protocol has a reference to the creation of a multilateral investment court. I can see you, but I cannot hear you.
Well, let me jump on this, Jose, so I make the life of our dear ambassador easier. No, there's no reference. There's no reference to a multilateral investment court in the protocol, and we can come back to that after Saja also talks about the various approaches on the continent. But just to jump on that, Jose, because I think it's a very important point you are raising. I would like to bring to the attention of the colleagues and friends here that the idea of having a permanent court to deal with investment disputes was actually put on the table during the negotiation of the Pan-African Investment Code. So the idea is quite often presented as an idea of the European Union, but I can tell you I was involved in the negotiations of the Pan-African Investment Code, that at some point there was even in the text of the provision of dispute settlement, a reference to an African Court of Investment Arbitration that was put in brackets. And then we deleted it at the last minute because states were scared about cost, etc. But the idea of a permanent court to settle investment disputes is not a European Union idea. And Ahmed can also jump on that, because if you even go earlier, institutions like the Organization of Islamic Cooperation had already this idea of a permanent court. So I'm just insisting on that, because I think it's not right that this is always presented only as a European Union idea, when as a regions like Africa put it already on the table. But in the protocol, there's no reference at all to that, but we can come back to that afterwards. So to give more elements. Thank you.
Yes, Michael, I believe that you wanted to share some thoughts very quickly. Yes.
Oh, just a quick one. So thanks to Professor Makan. I don't have to answer the question, but maybe to ask him a question, since he was part of the negotiators, what is meant by the other mechanisms available to the host state? Because I saw this as an opening to existing mechanism, and he's smiling, so he has an answer.
Well, I mean, thank you so much, Ambassador. I don't want to preempt the discussion. I know that Jose has asked about the multilateral permanent court, and I responded on that. But of course, we'll come back to that in a few minutes. But as you know, Ambassador, there has been difficulties in agreeing on what would be the available dispute settlement mechanisms in case of dispute between investors and states. And I will come back to that, I think, after a few comments and presentation from Sadia. Thank you.
Thank you very much, Makan. I have plenty of questions, and I imagine that many more, but I would like to give the floor to Sadia and ask her about the various approaches to reform of investment arbitration in Africa, among others. Sadia, you have the floor.
Thank you very much, and bear with me again. I'd just like to project some slides here again. Just a second. Thank you. So again, like before I start outlining in detail the various approaches to dispute settlements, I just wanted to clarify with some data what we're talking about here in terms of treaty practice in Africa. Okay, so there are today 900 treaties that have been signed on the continent, and you can see, we try to map them here, out of which 541 are in force. So this is by no means a small sample. So there has been studies that could have been done thanks to these treaties that are published on what the approach was. And what I was particularly interested in, because when we were working on reform, is to look at what is the practice in the past couple of years. Okay, so I have mapped out here a list of treaties that have been signed in the last 6 years. Okay, just to show you that there's still treaties being signed, and which one are those? And, some of them are in force, some of them are not in force. That's another question. But if you look at these treaties in particular, because I know there's had been a lot of discourse, and I'm going to get to this, on the backlash against investor-state dispute settlements and against the resolution of disputes before an investment arbitration tribunal, you will probably not be surprised to hear that the majority of these treaties are still including investor-state arbitration clauses. Okay, in the sense of traditional going to an investment tribunal, whether it's ICSID or ad hoc or others. Okay, so I think this is the first point. Now, of course, there are exceptions. Okay, there are exceptions, and you know which ones are the exceptions. The Brazilian, for example, Brazil is notorious for moving away from investor-state arbitration. You have others that are kind of limiting the right to investor-state arbitration, but this is the first I think, element that I wanted to put out there. The second thing that I wanted to mention was that what we see in terms of the approaches is that there is a huge emphasis that is put on dispute prevention. I think I wanted to insist on this. We talked about facilitation of investment. I think this is also very important. In the new treaties, how do you prevent disputes, okay? And you can prevent disputes multiple ways, but one way that has been identified is through the institutional way, which is we create specific committees. Now, whether they're joint committees at the level of states and BITs, I'll give you some examples, this is one thing, or whether they're at the national level. You have a movement of reform right now when some states are adopting national committees that are in charge of resolving those disputes very early on. Okay. Now, of course, there's also an emphasis on mediation and negotiation, all of this, but I wanted to flag out the institutional way, the procedural way. And then secondly, and I know there's been a lot of talk about this on the substantive front, but I think it's important to mention that the general point is that there has been a rebalancing of procedural rights also in addition to substantive rights. And what do you mean by this? That means there's been a restriction of the scope of investors' dispute. So a tightening of the conditions precedent to ISDS, for example. There has been, and Professor Bang mentioned it earlier, a movement towards an Africanization of disputes. So you would see more and more references to African institutions, okay? And there has been also movements towards admission expressly of counterclaims to rebalance everything out, okay? So in terms of the joint committees that I mentioned for prevention of disputes, I have just pulled out some recent examples here of joint committees for resolution of disputes. You have Morocco actually also came out with a model BIT in 2019, which refers to that. Morocco, Brazil also refused to that. So this is a specific joint committee state by state that will be in charge of preventing disputes when it happens. You have also a lot of emphasis put on mediation and negotiation. And here I've just given out just an example because the Morocco-Nigeria BIT refers to the dispute prevention mechanism in Article 26. Now, at the national level, I think it's also important to give some examples of what has been happening domestically. Egypt is a good example of what they did in 2017 is they actually created 2 new committees, a ministerial committee on investment dispute resolution, which is the resolution committee, and a settlement committee, okay, and a secretariat to kind of narrow down the institutions, that's the institutional reform I was talking about, to settle those disputes. And I will let the Egyptians in the room, if there are some, give some specific data because they weren't published. But my understanding of my conversation with our colleagues in Egypt is that that has significantly reduced the numbers of cases in Egypt. Okay, so I think this is an important example to give. Now, I give some examples. I talked about it earlier. I cannot give you some specific examples of countries that have been adopting this just because it is in the process of being adopted and discussed, but I can tell you for sure that there are at least 2 and even more African states that are in the process right now of establishing national committees. So we're not talking here about joint committees state by state, but a national agency that would be in charge not only of being the focal point with the investors, which already exists, okay, for example, in Ivory Coast, that already exists, but to be in charge of negotiating treaties, of reforming treaties, of settling disputes. So all of these people will be the same ones. And as we all work with the governments and are part of governments, they know that there's a problem of coordination and coherence within the government. So this is essential. This is essential. An additional thing that I mentioned was in the rebalancing was tightening the conditions to ISDS. I'm not going to talk again about the restriction of the substantive standards, although these are also important to mention, right? If you tighten the substantive standards, it will have an effect on the dispute settlement, but more on like there's specific condition precedent that you need to respect before you file an investment state arbitration. And there are some examples here on what a request should include and, all the conditions that you have to go through beforehand before you can actually trigger the ISDS or push that button to submit a dispute to settlement. And here are some examples here. In terms of Africanization of disputes, There are references here. I mean, these are just illustrations. These are not exhaustive examples, but of BITs that are recent and then have referred to regional centers for dispute settlement. I just think it speaks volumes because you're moving away from a standard clause where it's just ICSID or ad hoc. Here you have some specific mentions of, some regional centers. So you have Mauritania and Turkey, Burkina Faso, Turkey, Rwanda and Central African Republic, which are just recent examples. And then, of course, you have examples of treaties that refer to counterclaims, which is here I just mentioned SADC, but of course there are others because this is just a model BIT, which expressly point out that you can have counterclaims in investment arbitration. Now, I cannot, of course, not mention some other approaches, which is question mark, are we moving away from ISDS in certain parts of the continent? Of course, you know that South Africa is a notorious example of a country that has terminated its BITs. And with its largest investor states, which is giving a signal as I am actually moving away from the whole system of treaty protection at ISDS. So here you have a list of the recent ones that they have terminated, at least with the biggest economies in South Africa. And of course, in 2015, there has been a legislation change which actively prohibits investor state arbitration and emphasize on mediation in domestic courts. And you can consent to arbitration, but only after exhaustion of domestic remedies and state to state, and it's only state to state arbitration. So you see that there's an example of no, we don't want ISDS at all. Okay. Now there's also other examples that I haven't put here, but for example, in Ivory Coast, in the reform that I mentioned in 2018, there's not a ban on investor state arbitration, but beforehand, they would have direct consent to investor state arbitration through the investment code. And this has also changed. Now you don't have direct consent anymore. You just have a mention that you can go to arbitration. There's still the possibilities, and there's an express reference to arbitration before, the African Court of Arbitration, the Cour de Justice des Communautés Africaines, CCJA in Ivory Coast. And also you can still go to investor state arbitration to another tribunal, but then you'll have to agree. So you see that, there's a lot of, what I wanted to say is there is a lot of movement in Africa, which some may qualify as fragmented because you see South Africa is like, no, we don't want ISDS. And then there's the reality when you kind of zoom in, the practice is that you see that in fact, in the last 6 years, you still have BITs that are referring to ISDS provision expressly, and that they're being just focusing more on dispute prevention, I would say, and rebalancing those procedural rights by giving, more options to investors to settle the dispute, but also rethink whether they want to settle the dispute or not because of those conditioned precedents that are there. The venues for bringing those disputes are much more balanced as well. So they're not just always at the same place. And then there's this whole discourse on counterclaims, of course. Can you bring counterclaims expressly or not? And I can also say to you that there are some ongoing discussions on, because there's such a big list of obligations of investors, right? And not just rights. Would there be a possibility for a state to bring a claim against an investor? So this is like future discussion, okay? It's not yet in treaties, not just by way of counterclaim, but directly, through another mechanism. And how could that be implemented? I know states have voiced that concern a lot. And I'm going to stop here because I know that my time is up. Thank you very much.
Thank you very much, Sadia. This is a very comprehensive geography of the various movements that have been going on, that are going and that are new in the African continent with respect to investment treaties. We are very close to our deadline. So what I would like to do now is, before we finish, I would like to ask a very particular question, which is more informative, and then give each one of you the floor, including Hamed, to share any final remark that you would like to share. Think about, what's important, what is the contribution not only by the protocol to the African continent, but the contribution by the protocol to the rest of movement and reform, procedurally, but also substantive in ISDS and in investment disputes. So the question is informative. When will the protocol be applicable? When will it enter into force? That is a big question that many may be thinking. We now have a protocol. We know the text. We know the substance. But when will it be applicable? And I'll stop there, and then in the following order, Susie, and then Hamed, Professor Makan, Michael, and then Sadia.
I mean, thank you very much. The informative question, I assume, is maybe for Professor Makan, or maybe I will defer for him for the response regarding the entry into force of the protocol. But from my perspective, two final comments, maybe after listening all the excellent intervention from other colleagues. One thing is, I think on dispute settlement, of course, this is not a secret, but this is where we have the difficulties. This is where the continent still have to come up with a coherent and consistent approach. But I think the most important thing is that negotiators want to do good. Negotiators want to come with innovation. And I am pretty confident that we will get with something innovative, with something that will work for all the continent. And it's really important to also have a look on what is going on at Institutional Working Group 3, because in a way or another, we will have some interaction and some implication between the two processes. So that's something I want to put on the table. But I think that's something we will have to see regarding the next part of the negotiation. But yes, the challenge, I think the continent will be able to manage this challenge. A second thing I want to highlight here is we also have to be careful when we talk about treaty reform, and Sadia referred to that at some point. We also have to make sure that we are not only focusing on investment treaties and reforming and updating investment treaties. We have investment laws, we have investment contracts. So we have many other legal instruments that are also on need of reform or enhancing or alignment with sustainable development. So let's also make sure in Africa, but also in any region of the world, but we are also looking on the domestic laws, on the investment contract, because when they are not well designed or negotiated, they are also bringing a lot of risk and problems on sustainable investment governance. So I will stop here for my perspective. Thank you.
Thank you very much, Susie. Hamed?
Yes, thank you very much, Jose. I think I would just two points. The first one is a little bit less optimistic. The second one is very optimistic. Less optimistic is that if you look what is happening in terms of IIA reform, there is a tendency to fix things on the outside, meaning to renovate the house, to choose what color should I paint the walls, how many rooms do we want, what kind of tiles for the floor. But it is really time to go and to check the foundations of the house. It's very nice to renovate, but the foundation need to be looked at urgently and to be renovated in a serious matter. It is no longer possible for a foundation that has been developed 40 years ago to bind states today when we are telling them to fight pandemics, to fight climate change, to take the implications of wars that are happening far away from them. And there is a need for more flexibility and for a regime that empowers states to have a win-win relationship with investors. The second point is really, and this is a very important thing, is how the protocol positions Africa, really does position Africa to become, you know, a new global leader in terms of innovative formulation of investment policies for sustainable development. It is not just words. If you look at the treaty, you will see that African countries were able to go beyond fighting for their narrow, small interests to open up and to listen to other interests of other countries to come together. I will give you a concrete example. Africa is responsible for 3.8 only of green gas emissions, 3.8% only. And guess what the protocol has? Not any other treaties from other countries. The protocol has a dedicated provision on investment and climate change. The protocol has a dedicated provision on investment and the pandemics, saying it the way it is, because, you know, I mean, it's from this perspective that really the protocol is groundbreaking. And I really look forward to having the protocol implemented, and looking forward to continue working with Professor Makan and the task force. And they have, of course, they know the full support of UNCTAD moving on that. Thank you very much.
Thank you very much, Hamed. Now, let me include one question, which I believe is very relevant for the following concluding remarks from those that haven't spoken on concluding remark. The question is related to the hard law obligations for investors. Normally, the obligations for investors are an issue that is either addressed in investment arbitrations as obligations of domestic law, and obligations of the local law when the investment is made. So there have been some doubts as to whether by creating investment obligations for investors, the domestic jurisdiction may be supplanted by the jurisdiction of the tribunal. That is some concern that some have raised. It's not, and I want to clarify, it's not my concern, but I know that some have raised the concern. Well, are you supplanting domestic courts? Are you taking away from the jurisdiction of domestic court what should be decided by domestic courts? So is that a risk? Do you see that as a problem? So I put that out there for any of you who may want to answer that. So next in line, I believe, was Ambassador Michael.
Thank you, Jose. I'll just quickly start with your last question and say, perhaps in terms of the submissions and comments of the African member states, it is why they've been calling for recourse to domestic courts in some of the reform options, because you don't want to get to this issue of supplanting the domestic jurisdiction. But it's an important question which you've raised. To the previous questions which you've asked, I just wanted to quickly share 3 points. We've listened to the important groundbreaking presentation on the AfCFTA, but also the new trends in international investment agreement. I think this conversation needs to be broadened. Sometimes we talk about international investment law in the quite esoteric sense. I think getting to the investment communities that are hosting investment, but also political actors. It's quite important to address fragmentation and ensuring that we deal with the challenges of existing BITs or existing investment, whether it's contract, investment agreement. The second point really is to just build on what has been said by Suzanne and Hamed, and this is really, and linking it to perhaps conversation at the UN. Investment law can be an instrument for good. Investment law can address potential issues of inequality and inequity, and this could be linked to also perhaps addressing issue of redistribution in terms of global financing. And when the Addis Ababa agenda was concluded to finance the SDGs, a specific provisions or part dealt with this issue of private investment and ensuring that private investment play a role in financing the SDGs. What the negotiators of the FCT have been able to do is to collapse the two and bring the two together. So again, I must congratulate the negotiators for being able to link the Addis Ababa agenda on financing and investment law in that regard. And finally, for negotiators in UNCITRAL Working Group 3, particularly for African states, what the AFCT has provided is really the impetus to push forward some of the views on the procedural reform options. I know there's a different interpretation of the mandate, but now there's clear direction as to where the African states that are state parties to the AFCT want to go, and I think that's very important. Thank you.
Thank you very much, Michael. Professor Makane?
Yes, thank you. Thank you very much, Jose. There's a lot of food for thought, of course, and you ask about the entry into force of the protocol. So the protocol will enter into force. Well, first of all, the protocol has been adopted in February. I think it's important for everyone here to have this information that it has been adopted in February by the Assembly of Head of States and Governments of the African Union. So it was negotiated in less than a year. And so when you hear about all the innovative features and characters and realize that African countries were able to negotiate all that in less than a year, it's rather impressive, I would say. So the protocol will enter into force after the deposit of 22 instruments of ratification. So 30 days after the deposit of the 22nd instrument of ratification. So we need, out of 55 states, 22 states ratifying the protocol. What I can say, Jose, and it leads me to some of the concluding remarks I wanted to make, is that there's no way this protocol will enter into force without, a deal on dispute settlement. This, I think, is very important to keep in mind. I saw in the chat box that my dear sister Rose Ramo was asking about the Pan-African Investment Code and the fact that the Pan-African Investment Code was not adopted as a treaty, but as a model. But the reason why the Pan-African Investment Code failed as a treaty is because there was no consensus on dispute settlement, and in particular on ISDS. So in Africa, we have already a precedent, we have already an example of a situation where economic integration failed, investment integration failed because states were not able to reach consensus on ISDS. And there's no way that most of the countries in Africa will ratify the investment protocol if they do not agree on dispute settlement. And so for me, one of the lessons for the world from the process of the investment protocol is that it's easier nowadays to reform on the substantive level than to reform on the procedural level. It's easier to build consensus on substance than to build consensus on procedure. And so what does it mean? It means that we need to accept an approach à la carte. When it comes to procedural aspects, reform will have to be à la carte. It's not only for Africa, it's for the entire world. I think that Ambassador Michael, this is also for me a message that applies for UNCITRAL Working Group 3. It will be very hard to come today with one uniform, one monolithic approach to how investment disputes must be settled. And I think that Sadia has done a fantastic job to show how the landscape is fragmented in Africa when it comes to approaches to dispute settlement. So the mandate that has been given now is to negotiate this year, is to negotiate an annex on dispute settlement to the protocol. So we agree that there will be 3 avenues: state-state dispute settlement, dispute prevention, and investor-state dispute resolution, but we don't want to call it ISDS. We call it just dispute resolution. We don't want to call it ISDS, but it's like ISDS. So we agree that there will be those 3 avenues. And now African states have to negotiate detailed rules and procedures regarding each of those avenues. And this is where the stakes are high when it comes to investment dispute resolution. What will be the available mechanisms? Should we go for a permanent court? Should we go for regional court? Should we go for domestic court? Should we only go for mediation? Should we go for investment arbitration? These are the options that are on the table. But my personal view, Jose, is that, you know, what will be successful is only reform à la carte. And if we go for reform à la carte, everyone will be happy, and everyone will see that the investment protocol is really reflecting its national investment policies. But my last thing, Jose, the pride that I have when I look at this investment protocol, and by the way, it is now available to the entire world because it has been leaked last week. It was not yet publicly available for a reason I ignore, but it has been leaked last week, so it's available to the entire world. And I think that when the entire world would look at this protocol, you know, people will be proud of what the African continent has done. And for me, what matters is that today Africa can bring its voice in the shaping and the reform of the investment regime. And this is definitely what we have done with the investment protocol. Thank you.
Thank you very much, Professor Makan. I'm going to give Sadia just a 3-minute remark time, and I apologize to everyone. I know that one of the features of World Arbitration Update is to have our rooms where people can gather and talk, but we have another session in 10 minutes. So Sadia, you have the floor for 2-3 minutes, and then we close.
Well, thank you very much. And I don't want to keep you, everybody else from the next session, but very brief remarks, because everything I think very important has already been said. I think one point that I will make is, first of all, the backlash against investment arbitration that we have hearing all over the world, not just in Africa, but everywhere. People have been confusing the necessary, you know, changes in substantive obligation and the procedure for invested state resolution. They're on the first part on the substantive changes. We have just shown to you how the investment protocol of AFCFTA has made drastic changes, you know, on rebalancing the rights between investors and states in the following the footpaths of the Pan Investment African Court and other you know, BITs that we have flagged. The second thing is on the procedure. There has been changes as well done by major institutions recently to reform and address concerns of ISDS. And what I'm going to say on a personal note here is my concern is I don't want African countries to be shooting themselves on the foot by having a protocol where they actually give themselves less rights, less procedural rights to their own African investors, as opposed to those that they would give to investors from foreign countries. As I have told you, the BITs with third countries still incorporate those ISDS provisions. So I think this is very important to keep in mind. And we don't want to enter into a situation where, okay, we want to promote African investment, and then when it comes to dispute settlement, we create a system that would not, you know, that would be very different from the one that we offer to other countries, and that would be less attractive and honestly less balanced as well. Anyways, I'll stop on this. Thank you very much.
Thank you, Sadia, and thank you everyone here in this panel. I would like to say thank you, Susie, Hamed, Ambassador Michael, and Professor Makan. It has been an incredible pleasure. We've had very positive remarks throughout the hour. I apologize to our audience. Normally we do breakout rooms so that you can meet the stars. Now, this is the objective of WOW. The objective of WOW is to bring to the global platform experts like you who have worked on avant-garde provisions that will not only be dug up from the specific region and stay there, but that they would be made examples for the rest of the world in terms of investment arbitration, international commercial arbitration, and public international law. For those that may believe that not everything has to be arbitration, we have public international law there, which encompasses so many things. So thank you. We are grateful to you, and we hope that you can join the next panels. And we will be posting the session as soon as we can, and the WOW ends. But please, stay with us for the following sessions, etc. So lovely day. Thank you.
Jose, you need to advertise that the next one will be in Africa. Huh?
Oh yes, yes. Thank you. So we are working on a project with Professor Makan to have a impromptu World Arbitration Update Africa Day with various panels, and we do not have the date yet, but it would be in person in Africa, hopefully in 2023, as soon as this summer. But the plans are in the making. Okay. Have a beautiful day, and thank you.
Thank you very much. Thank you, everyone.